It is now possible to commit a hate crime in your own home, if you live in Scotland, at least. And before you start laughing and click away from the video, this is not an April Fool's joke. For one, we've gone 12 o'clock here in the United Kingdom, and secondly, I am deadly serious. In fact, this law was passed into legislation in 2021. It's the Hate Crime and Public Order Scotland Act of 2021, and under Section 4 creates the offence of stirring up hatred, which I'll go into in a minute. What it doesn't do is specify that this is in a public place. So, for example, what you might be familiar with as ordinary public order offences, they have to be in a public place in order to be an offence. Now, if you spent any time on X, formerly Twitter, as the newspapers usually insist, today, you'll have seen lots of posts, including those that have embroiled turmoil for J.K. Rowling, and the police, Scotland, now say that they might be investigating her for her tweets online. You can discover those if you follow me on X, Twitter, whatever, at D. Shensmith. So first of all, if you're new to me, I'm Daniel Shensmith, the Barrister of England and Wales, although I am talking about Scotland, as many people do like me to specify when I do my videos. So make sure you do subscribe and hit the like button, because that's how YouTube knows that you're watching and you like my content. So first of all, it's a little bit odd in that, on the one hand, Police Scotland say that they are going to investigate all of these offences, and yet just not long ago, last month in fact, said that it's no longer able to investigate low-level crimes, or every low-level crime, including those that have cases of theft and criminal damage. So how then has it pledged to investigate every hate crime that it receives? Now, herein lies the irony, because there's lots of different interpretations of what this hate crime might be, and of course there is a defence to it. Many complaints have been raised that it is eroding free speech, because particularly if it's said in your own home but stirs up hatred of some kind, could still be chalked up to be an offence. Now, let's go through the offence first, and then we'll come back to why there is a huge degree of irony. And I'm not just talking about the date that it came into force, being the 1st of April. Let's go through the offence first. A person commits an offence if the person behaves in a manner that a reasonable person, so an objective test, would consider to be threatening, abusive, or insulting, or communicates to another material that a reasonable person would consider to be threatening, abusive, or insulting. Now, the usual test for something that creates alarm and distress is that which must cross a threshold to become oppressive and unacceptable. But this doesn't make any particular reference to that. Either, in doing so, this goes on, the person intends to stir up hatred against a group of persons based on the group defined by reference to race, colour, nationality, including citizenship, ethnic or national origins, or a reasonable person would consider that the behaviour or communication of the material is likely to result in hatred being stirred up against such a group. So let's just recap that a moment. A person commits an offence if the person behaves in that way or communicates to someone else, either in doing so intending to stir up hatred against a group of persons, or a reasonable person would consider the behaviour or the communication of the material to be likely to result in hatred being stirred up against such a group. And there's another offence which you go on to here, but I'll come back to offence 1 in a moment. Secondly, a person commits an offence if the person behaves in a manner that a reasonable person would consider to be threatening or abusive, or communicates to another material that a reasonable person would consider to be threatening or abusive, and in doing so the person intends to stir up hatred against a group of persons based on the group being defined by reference to characteristics mentioned under 3 below, that those being age, disability, religion, or in the case of a social or cultural group, perceived religious affiliation, sexual orientation, transgender identity, which has been one that has been discussed quite in detail on X today, all variations in sex characteristics. Now, there is a defence available. It is a defence for a person charged with an offence under this section to show that the behaviour or the communication of the material was, in the particular circumstances, reasonable. So how on earth is anyone really going to determine that? Well, as we've seen over the years, interpretation of this law in the grand scheme of things by the general public, and dare I say it, by police forces around the country, can vary, because it is not absolutely crystal clear from the wording of this what is reasonable. All it does say is point us back to the freedom of expression, which is where we started in the first place before the law came about. And that says, under subsection 5 here, for the purposes of subsection 4 being reasonable, in determining whether behaviour or communication was reasonable, particular regard must be had to the importance of the right to freedom of expression by virtue of Article 10 of ECHR, including the general principle that the right applies to the expression of information or ideas that offend, shock or disturb. So call me cynical, but I detect a contradiction here. So for the purposes of these offences, in determining whether it's reasonable, particular regard must be had to the freedom of expression under ECHR, and including the right to the expression of information or ideas that offend, shock, or disturb. So whilst there is a clear distinction of words here, which most lawyers probably find abundantly clear, with respect, I do suspect that a large chunk of the population will just not get the difference between the two. Because the offences under sections 1 and 2 refer to whether a reasonable person would consider the behaviour to be threatening, abusive, or insulting, or whether materials communicated would be threatening, abusive, or insulting. And the offence under section 2 also refers to whether a reasonable person would consider the behaviour to be threatening or abusive. However, particular regard should be had to the freedom of expression under the defence, which is clarified under subsection 5, to the principle that applies to the expression of information for ideas that offend, shock, or disturb. So we're looking at a distinction here between threatening and abusive behaviour and that which might shock, offend, or disturb. Now, how on earth is anyone really going to prove beyond any reasonable doubt the difference between the two? If there is a direct threat made from one person to another, and obviously I'm not condoning any such thing, if there were a direct threat from one person to another, then that's absolutely clear. If one person were continually abusing another person online, then that might be absolutely clear. But if it is just conveying ideas that offend, conveying ideas that shock people, or conveying ideas that disturb people, this should be maintained under the right to the freedom of expression by virtue of Article 10 in ECHR. But the huge problem here, of course, is that this section does not refer to these being in a public place. They could be in a public place, they could be in a private place, and they could be online. It just says that the ways people might communicate material to another person might be displaying, publishing, or distributing material, giving, sending, showing, playing material to another person, making it available to another person in any other way. And as to the behaviour, it just says that it includes behaviour of any kind, in particular things that a person says or otherwise communicates, as well as things that that person does. So that obviously could be anywhere, in public, in private, and even online. But coming back to the huge point of irony is this speech here, which I've seen replicated again and again and again on X, with people drawing a distinction between everything I've just said about this piece of law, whereby if someone is communicating material to somebody that a reasonable person considers to be threatening, abusive, or insulting, and in doing so intends to stir up hatred. Now, some people online, many in fact that I've read comments on X today, have likened this speech by Humza Yousaf, First Minister of Scotland, to this piece of legislation. And some people might believe, referring to subsection 1b here, that a reasonable person might consider this communication, i.e. this speech and this material, to be likely to result in hatred being stirred up against such a group based with reference to race, colour, nationality, including citizenship, etc. Just have a listen to this and let me know in the comments what you think. But of course, my video here is all educational and I have no intention to stir up any hatred with anybody whatsoever. Not that I'm even in Scotland, but that's not the point. Listen to this.
But why are we so surprised when the most senior positions in Scotland are filled almost exclusively by those who are white? Take my portfolio alone. The Lord President, white. The Lord Justice Clerk, white. Every High Court judge, white. The Lord Advocate, white. The Solicitor General, white. The Chief Constable, white. Every Deputy Chief Constable, white.
And it goes on, but you get the irony. I mean, I'm not for a moment saying that Humza Yousaf has committed an offence here. What I'm saying is the conversation on X has certainly been comparing this speech with the new legislation, with the double irony of it being the 1st of April. Because this clearly makes it an offence for somebody to communicate material which another person might reasonably consider to be threatening, abusive or insulting. Now, many people, I dare say, might be insulted by that, particularly those in Scotland, considering a quick Google search later says audit.scot. Audit Scotland says that according to population data, 95.4% of the Scottish population report their ethnicity as white. So as I say, many people might be insulted by that communication, which is within the wording of this legislation. And B, either that in doing so the person intends to stir up hatred, or a reasonable person would consider the behaviour of the communication likely to result in hatred being stirred up against such a group. So what are we to think? Because I, for one, think this is not just ironic, but a dangerous slippery slope towards eroding free speech, including that in your own home and online. Now, of course, I'm not condoning hatred and insulting or threatening behaviour against each other. I don't do that. I wouldn't do that. I've always condemned that, and I've been quite clear about that on my channel from day one. But I do believe that legislation like this is going to cause confusion, not just for the public, but for police forces as well. And I believe that Police Scotland are going to struggle to deal with not just the amount of reports they'll get, because this, I believe, will be weaponized by certain groups, and it's going to cause mayhem for both the public and the police alike. So overall, whilst the intent might be good to stamp out threatening, abusive and hateful behaviour, I just think this is going to cause more trouble than it's worth. Let me know what you think in the comments, respectfully and politely please, particularly if you live in Scotland. So let this be a warning to you that this now might have ramifications for the foreseeable future. Let me know what you think, and thank you for watching.